purchase of certain real property. And resulting from those negotiations, Bay Street Capital transferred $300,000 to my client to be held in escrow. There appears to have been a dispute between the buyer and the seller on whether there was or was not a contract entered into. And Bay Street Capital demanded return of those escrow funds while CA&R would not agree to the release of those funds. So at this point, my client's just an innocent stakeholder in this and wishes to deposit those funds with the court pending a resolution of the dispute between those two parties based on the cross-claim that I believe Bay Street filed last month.
Okay.
And after conferring with both the defendants, neither defendant was necessarily opposed to the relief being sought in this motion.
Is that accurate?
Yes, Your Honor.
Let's just go ahead and let each party state who they're representing and if they agree to the depositing in the registry of the court.
John Janicek for Bay Street Capital, and yes, we are in agreement that it's appropriate to deposit the funds in the registry of the court.
Okay.
Kimberly Pinkerton for Faustino Reyes and CA&R Management Company, and we are in agreement to have the earnest money deposited in the registry of the court.
What about who's representing Faustino Reyes?
I am, Your Honor.
You are. Okay, them as well. Okay, so that's all parties. Okay, I just want to make sure it wasn't clear from what was provided if this was agreed to or not. So that's the main reason I wanted to have a hearing. So anything else we need to chat about? Let's just check this. It sounds like we probably need to set this for trial. When do y'all want to be set for trial? Guys, any suggestions?
At your discretion, Your Honor.
I mean, how long is it going to take to get ready? This is kind of an unusual case. So how long do you think you'll need?
I don't believe it to be requiring a great deal of fact investigation or discovery, so I wouldn't think it would take too long to prepare for trial.
January, February, March of next year. What are you thinking? April, June, July, May?
February, March.
Ms. Pinkerton, does that seem like enough time to you?
Yes, just depending on when it is in February or March.
When would you like in February, March?
Either the beginning of February or late in March, around spring break, past spring break.
Mr. Janicek, Mr. Hakari. Mr. Hakari, you going to even be involved in this at that point?
No, sir. This today's actions will resolve my client's interest in this.
Okay.
I have a trial set for the last week of March. I don't know when spring break is in March. I'm assuming that's probably the 20th. So I'm available the 6th or the 13th of March, those weeks.
13th is probably when spring break is going to be. I imagine it'll be. Is this going to be a jury or non-jury case?
I would say non-jury.
Agreed.
Uh,
So then I could, the 20th, if that's not spring break, would be available.
Well, spring break is one. Do one of you guys have? The only issue with spring break for me is that it's going to be a non-jury week, and so do you guys have kids that you're going to be doing stuff with, or do you? It might be better if you could have a non-jury to do it on spring break, but I don't know, Ms. Pinkerton, what is your situation?
I have kids, Your Honor.
Okay, let's do it a different day then. Do you want to do the 7th or the February 28th?
I can do the 7th.
Genesect?
The 7th of March, yes, that works for me.
Rhonda, go ahead and set it for the 7th, and then who do you want to use as a mediator?
Mr. Is it Olden or I don't know. Who do you suggest, Your Honor?
Did you say old
Chris.
man?
Chris Oldner, I believe is his
Oh,
name.
Older.
Not old man.
I thought you said we ought to get that old man, and I'm like, that doesn't narrow it down a whole lot in mitigation. So, I don't know Oldner if that's someone you like, and Miss Janicek agrees to. I don't really know him.
Do you have a suggestion?
I was thinking someone like this. This is a dispute over what exactly is the dispute over?
Whether or not there's a contract.
On his contract. So maybe a former judge like Jim Jordan or Marty Lauer's retired. King Pfeiffer might be good. Jeff Kaplan is probably kind of expensive. But Ken Rubenstein is good. Mr. Janicek, do you have any suggestions?
Yes, I'm trying to pull up. There's a former judge with Jams here in Dallas that
Harlan Martin or Whittington or
Whittington, yes, Mark Whittington.
Mark Whittington's fine with me. I don't really care.
Yeah, I'm not opposed.
All right, let's go ahead and do Mark Whittington, Rhonda. All right. I've signed the order. I've scanned it. It should be hopefully in the system by tomorrow.
Thank you very much, Your Honor.
All right.
Thank
You
you,
have a
Your
great
Honor.
rest of your day.
Thank you, you too.
Thank you.
Okay. Are all sides here on the next case? I saw Mr. Alberts here. It may not be time yet. Let me see.
Good morning, Your Honor.
Good morning. Are you here on the Prestonwood Pond versus Wake Capital case? Are both sides here on that, or it's not time yet, so I'm not trying to rush anybody.
That is the case I'm here on, and I do not see Mr. Hafen.
He's here.
I just jumped in.
Okay, there you go.
Your Honor.
Okay. All right, let's go on the record on DC 215659. And this is all the attorneys involved in this case.
On our side, Your Honor.
Yes, correct, Your Honor.
DC 215659, Prestonwood Pond versus Wake Capital et al. Counsel, make your appearances.
Good morning, Your Honor. I'm John Hafen on behalf of the movants.
Your Honor, Chris Albert, on behalf of the plaintiff, the respondent in this motion.
Okay, let's proceed.
Good morning, Your Honor. So I represent the defendants Wake Capital Incorporated, Wake Capital LLC, Healthy Co LLC, American Construction LLC, and Daniel D. Waite. After the filing of plaintiff's original petition, we filed special exceptions because there were very broadly pled claims in the original petition, and we were unable to determine what claims were pled against what defendants. And there were simply facts, there were no allegations of fact that supported several of the claims that had been asserted. I'll note that as of Friday afternoon, I did receive the first amended petition filed by plaintiff, which has addressed some of, but not all of the issues raised in the special exceptions. And so if I could, I'd like to just briefly go through each cause of action and try to clarify what is still before the court. It appears there have been some non-suits, not expressly stated, but that seem apparent from the lack of certain defendants being included in some of these claims. So if I could, I'd just like to go through the cause of action and make sure my understanding is correct. And so we can make sure we understand what's before the court at this point.
Sounds good.
So with respect to count one, breach of contract, it appears that cause of action has now been limited to the defendant Wake Capital Incorporated is the only party against whom that cause of action is brought. So I just want to confirm that my understanding is correct on that front.
Is that correct?
That is correct.
Okay, that's all I need on count one. Count two, fraud. Similarly, this was previously pled against all defendants. It appears that this claim is now limited to Daniel Waite individually. It's the only party against whom that fraud claim is brought. Is that correct?
Well, Your Honor, I just want to clarify what we're here on. There's a special exceptions as to paragraphs 37 through 40 and 41 and 42, which are the fraud and unjust enrichment counts. That's all I have special exceptions on. And so
yes, Your Honor, we specifically raised the issue that they alleged a fraud claim against defendants collectively in referencing those paragraphs. I acknowledge that they have since amended the petition. And so for the sake of clarifying what parties are in play in these claims, I'm raising that issue again because it now appears, and I'm just trying to confirm, that Daniel Waite individually is the only party against whom that fraud claim is brought, but there is some uncertainty based on the way the pleadings have been alleged. So I'm trying to confirm that fact.
well, so fraud and unjust enrichment, Your Honor, that's what I'm here and prepared to respond to. And that's what we addressed in relation to the special exceptions. What we're covering here, though, appears to be all the causes of action, and that's not in the special exceptions.
Your Honor, again, I acknowledge they filed an amended petition last Friday, months after we filed the special exceptions and right before we had this hearing this morning.
So what are we fighting over exactly? What is it that you want to, what do you feel has been adequate?
Yeah, it's the same reason I filed the special exceptions, which I'm trying to clarify what claims have been alleged against what defendants so that I can properly address those claims.
And Your Honor, the special exceptions that I'm looking at here addresses paragraphs 37 through 40, the fraud count, and 41 and 42, the unjust enrichment count. Nothing else is raised in the special exceptions, and nothing else. We did amend our pleading, but that doesn't change that the special exceptions are limited to fraud and unjust enrichment.
Your Honor, I'll note in our special exceptions, our primary issue with the fraud claim is they didn't identify the defendant against whom they were bringing that claim. And so all I'm trying to do is confirm that by virtue of
so there's three, it looks like there's three sets of special exceptions. Which one are we dealing with?
So right now I'm addressing the special exceptions related to the fraud, the special exception.
No. There's a Daniel, what I'm saying is there's a Daniel Waite special exception. There's an American. Do they all have the same special exceptions? Oh, there may be more than three.
Yes, Your Honor, because again, the original petition alleged facts and claims against defendants collectively without specifying.
But what I'm asking, I'm not making this very clear. Which set of special exceptions was set for hearing today?
That's a great question. Defendant? I believe, well, that's a good question. I believe we intended to set it as to all of them. Yes, I mean, we set defendants collectively special exceptions for hearing today.
Well, at least the one I'm looking at, which is Daniel Waite's, which is, anyway, it's, you specially accepted the paragraphs 37, 38, 39, and 40, and the 41 and 42. I don't know if you were trying to set all of these special exceptions and they may be different. I don't know.
The substance is the same, Your Honor. And so with respect to the fraud claim.
So the only thing that needs to be replayed is for those paragraphs. Right.
Right. And again, they have repled. And so at this point, I'm just trying to confirm which defendant they are asserting the fraud claim against. That's really the core issue that we were concerned about with our special exceptions.
Okay.
So it appears based on the amendment that Daniel Waite is the only defendant against whom they now assert the fraud claim. And I'm trying to understand that that's correct so we can simplify and
Is that correct,
address.
Mr. Albert?
Yes, that's accurate.
Okay.
All right, anything else we need to talk about today then?
Yeah, so the final special exception, Your Honor, is with respect to unjust enrichment.
Okay,
First, I'll note, I think most courts in Texas, with the exception maybe Houston, acknowledge that is not an independent cause of action in Texas. However, the defendant must show that they obtained a benefit, or they must plead at this point. I'm not, of course, not arguing a motion for summary judgment, but they must allege facts that could show that a benefit was obtained from the plaintiff, and that benefit was obtained by fraud, duress, or the taking of an undue advantage. Now, if you read the facts in their amended petition, what they're saying is they're saying that the entity that entered into the contract breached the contract by allowing these other entities to be on the premises. And they're saying that Daniel Waite individually was fraudulent in inducing the plaintiff to enter into the contract. What they don't allege is how these other entities that I represent, these other defendants, they don't allege how they obtained an unjust enrichment by undue duress, fraud, or any other facts directed at the plaintiff. There's no allegation of that. And even if you deem that there is an unjust enrichment independent cause of action in Texas, which I don't believe there is in this district, but even if you believe there is, they still have to allege sufficient facts to show fraud, duress, or taking of undue advantage by those specific defendants, which they've not done so.
response?
Yes, Your Honor. So the core of this matter, just as a bit of background, is Daniel Waite signed a 5-year lease. I believe it was 5-year on behalf of one entity. However, he started running these multiple entities out of this space, and therefore each of these entities, American Construction, Health Eco LLC, the various other entities that were doing business, they were unjustly enriched in that they did not have to sign a lease or be according to plaintiff's counsel. He's asking who the breach of contract is directed to, and in hopes that we will not have a breach of contract against these other entities, which is the purpose of this. I guess the fraud, Your Honor, is that Mr. Waite signed this lease knowing full well that he would be running multiple businesses out of this space, and all these entities are essentially his alter ego, in that he would pay rent from the different entities depending on, whichever one he was cutting a check from. There is the fraud of signing up for the lease, saying that he would be renting it or leasing the space only on behalf of Waite Capital. However, with the intention of running these other businesses out of it. And those other businesses were unjustly enriched by being able to run their business out of a leased space without having to pay the lease.
Okay.
Again, Your Honor.
Yeah, I think if you feel like unjust enrichment, I've not heard this argument by anybody else before, but I'm not saying you're wrong, that unjust enrichment isn't recognized by the Dallas Court of Appeals, but that would probably be better sought or alleged in a motion for summary judgment, not in a special exception. So,
yeah, and Your Honor, just to be clear, I'm not alleging that as a ground for special exceptions. I'm not suggesting that requires dismissal in this hearing. What I'm saying is, if you deem there to be that cause of action, there are at least 3 entity defendants for which they don't allege facts that show there was a fraud, a duress, or a taking of undue advantage by those defendants. If you hear what he's saying, what counsel's saying, and if you read what they have in their petition, What they're saying is Daniel Waite was fraudulent in entering into this contract and made misrepresentations. And then the entity, Waite Capital Incorporated, breached the contract. And therefore, these other defendants were unjustly enriched. You can't do that. You have to allege a fraud, duress, or some undue advantage taken by those defendants in order to
Is there
establish
anything
that
pled,
claim.
Mr. Albert, that discusses what exactly these other defendants got out of this? Usually an unjust enrichment, at least that I've seen, is typically a situation where there's either a breach of contract or it's an alternative form of relief on the breach. It's usually not some third party that's being unjustly enriched, but I'm not saying that's impossible to do. It's just not how I've usually seen it. So I think there does need to be some kind of link there. So you do need to plead that. So I'll give you 14 days to plead that, to fit in that step. And Mr. Hoffman, go ahead and prepare a order for me on this, on that one point. The rest of the special exceptions 9. And make sure it says at the beginning, instead of on this day, that this was heard on August 29, 2022, that you share the order with Mr. Albert before you submit it, and get me the order by this Friday.
Okay.
You guys?
May I address one additional issue briefly, Your Honor? Just
Okay.
for clarification purposes. So, and I don't represent these individuals, and it's my understanding they have not yet been served, but there are 3 individual defendants, so Michael Pickett, Ryan Gannon, and Miles Clark, who are listed as defendants in the original petition. I still see them listed in the caption, but I don't see any allegations or claims asserted against them in this new petition. Generally, that would mean there's been a non-suit of those 3 defendants. I'm not sure if that was what was intended, but the caption still retains them. So I'm just trying to understand, for the purpose of trying to simplify the case.
Is that accurate? or
It
not?
is accurate that they are still in the style of the case. Your Honor, I'll just, even though it's not even part of this, I'll go on record saying we will clean that up as part of this in response to as
Are
our
you
repleting
non-suiting those 3
response.
defendants right now, or?
I'm unprepared to represent that we are. I believe that to be the case, Judge.
Okay, go ahead and deal with that one way or the other. So,
I will.
all right, thank you guys. You have a
Thank you,
great
Your Honor.
rest of your
Appreciate your
day.
time.
And
Thanks, Judge.